Great to see everyone here. What a great turnout. I also want to shout out to the Narja mob, and particularly Laura Hopkins, who I haven't seen for 20 years. Great to see you. Catch up with you after. But it's only right, of course, I start by acknowledging the traditional owners and custodians of the country we're meeting on today and pay respect to elders, leaders and knowledge holders past and present. And I extend that respect to all elders that are here and all First Nations people participating in this conference. I also want to acknowledge that the topic I'm about to discuss touches on a traumatic history, and I know probably virtually everyone in this room understands that, and many of the sessions have dealt with the same sort of material, but I want to acknowledge that it touches on a traumatic history, and my presentation, of course, won't reflect the breadth and extent of the violence and harms inflicted or the shared experience of Aboriginal people here today. I apologise in advance that the topics I discuss might be re-traumatising and triggering for many, but I also want to acknowledge the resilience, strength and leadership shown by Aboriginal communities, their elders and respected persons over many generations to ensure the fight for survival, justice, culture and country continues. This presentation, as you've heard, touches on the impacts of colonisation and in particular how those impacts contribute to over-incarceration. In doing so, of course, I acknowledge the majority of Aboriginal people never have and never will become involved in the criminal justice system. It is vitally important, of course, as you all here understand, to recognise the ongoing historic legacy of colonisation and its correlation with over-representation. The great 20th century American author William Faulkner wrote, "The past is never dead. It's not even past." Sitting in the County Koori Court, I see evidence of the validity of that phrase on a weekly basis. Aboriginal people coming through the courts occupy a unique space vis-a-vis the justice system, the state and the rest of the community. As you all understand, Aboriginal people have a shared experience unique to their community. It starts with dispossession from this land and the violence, atrocities and outrages inherent in that process, the removals, the kidnappings, the massacres from the outset, destruction to a large extent of a way of life and social structure. The shared experience includes government and legislative control. I know this is known to all of you, of course, but I'm making the point that there is a unique experience vis-a-vis the law. Discrimination over many generations, misguided and destructive government policies, the mission, existence and experience, the stolen generations, racism and disrespect, disadvantage, poverty, a unique position vis-a-vis the law. The knock-on effects of these experiences are well known. Despair, the violence and excesses associated with these experiences, negative experiences with the organs of the state, particularly police and the courts, but also health, education, and of course over-representation in custody. Now that's an inadequate list. It involves a lot of shorthand for what's very multi-layered and complex matters. These and many other influences and consequences can be rolled into the phrase intergenerational trauma or transgenerational trauma. So where do concepts such as intergenerational trauma, historic trauma and disadvantage, systemic discrimination and other impacts of colonisation sit within the existing sentencing discipline in this jurisdiction? As the topic of this session anticipates, the impacts of these factors as we currently understand them might affect an assessment of the degree of subjective responsibility an offender has for their offending. How this comes about requires some analysis of the development of the jurisprudence relating to subjective responsibility and sentencing principles. You may notice I've preferred the term subjective responsibility to moral responsibility or moral culpability, but the terms are of course interchangeable. You'll see them, different cases refer to the same concept using those different phrases. Moral culpability, moral responsibility, in my view, are loaded terms in the sense that the descriptor moral carries echoes from the moral and religious philosophy of the 18th and 19th centuries. What underpins the term moral responsibility is the notion of agency, that we all have moral agency and are responsible for our conduct. It's a term that reflects an era where breaches of the criminal law were viewed generally as moral failings rather than as an outcome due to forces and factors not of the perpetrator's making. The term reflects an era where courts made moral judgments on those who breached the law and handed out just deserts for their wickedness, with little regard to the drivers of criminal conduct. Those sitting in moral judgment, of course, held privileged positions of power, and maybe that hasn't changed so much. A moral judgment says something about the office holder making the judgment and the recipient, in particular where they sit vis-à-vis the law and the state. Unconscious bias, cultural bias, and actual bias based on 19th and early 20th century notions of superiority have shaped those moral judgments from the beginning. It's only in more recent years that legal authority has sought to illuminate just what this subjective responsibility or moral culpability is all about. It has always been assumed. Relatively recently, in historic terms, the Victorian Court of Appeal in Verdens considered the question in the context of a reduction in moral culpability due to mental impairment causally connected with the offending before the court. And in 2013, the High Court also approached the question in terms of reducing an offender's moral culpability due to profound childhood disadvantage in Bugmy. These cases will be known to many of you, and to an extent this session assumes some knowledge of those principles. A judge's assessment of moral culpability is concerned in these cases with assessing a degree of blameworthiness for offending as compared to a standard or norm, rather than assessing culpability through the lens of all relevant factors and circumstances that may have shaped the individual and may have had an explanatory or causative nexus with the offending. Of course, the norm doesn't usually find themselves in a criminal court to begin with, at least not for the type of offending Mr Bugmy faced court for. The philosophical assumptions that underpin the concept of moral culpability aren't fully examined in these authorities. They're examined, as I say, in the sense of, in Verdens, a reduction in moral culpability due to mental impairment; in Bugmy, a reduction due to childhood disadvantage or profound childhood disadvantage, as it was stated in that case, distinguishing that individual as someone with less moral culpability than a person from a stable and nurturing upbringing. Looking at our Sentencing Act, it doesn't provide a lot of illumination as to what the concept of subjective or moral responsibility involves, just that we have to have regard to it. Section 5.2 of the Sentencing Act provides that the court must have regard to the offender's culpability and degree of responsibility for the offence. So it's an important sentencing consideration, of course, but how is it to be done? What factors are taken into account? How is the assessment made? Moral responsibility, once upon a time, was a question of philosophy, probably a religious question in part, definitely a sociological one also, in the sense that we're talking about a British system of justice. It has increasingly become a scientific one. Capacity is central to criminal responsibility, and by extension, the degree of an offender's responsibility is relevant to sentencing. In relation to criminal responsibility, I'm going to quote the President of the Court of Appeal here, Justice Emerton, from her Melbourne University Law Review annual lecture titled Punishment and Responsibility, an Assessment of Moral Culpability in Sentencing, where Justice Emerton stated, "The accepted wisdom is that criminal responsibility is found in incapacity, capacity to reason, capacity to control impulses, human agency remains key, and the attribution of responsibility for specific action lies in human capacities of cognition, knowledge of circumstances, assessment of consequences, and volition, powers of self-control. It is only legitimate to hold people criminally responsible for things that they have the capacity to avoid doing. Philosophical and cultural assumptions as to moral responsibility have been shaped and overtaken somewhat over the past century by the sciences. Neuroscience, neuropsychology, cognitive psychology, psychiatry, the behavioural sciences, sociology have all left their mark on the assessment of subjective responsibility that courts engage in every day. In these sciences, courts have found causal factors for offending beyond the perpetrator's control. Philosophers are still writing papers, I suspect, on the notion of free will, but the neuroscientists say, forget it, we're solving it. We're all a bunch of algorithms. The point I'm trying to make is that science, rather than philosophy or morality or scripture, is informing us all at a rapid rate as to what makes the person appearing before the courts behave in the way that they do. And they've been making inroads into these domains for at least a century. The law catches up slowly. The intuition of judges has, for the most part, been backed up by the science over time. The approach of judges to assessing a person's blameworthiness for their conduct in breaching the law has become more nuanced over this period. Punishment as an end in itself is less in vogue, as science reveals little by little that in doing so we are punishing individuals to a degree for being themselves. Intuitively, courts have understood for many years, prior to Bugmy, that early childhood experience of exposure to violence, alcohol and other negative influences places that individual at a disadvantage compared to others who experienced a stable, nurturing environment. Intergenerational trauma as a phrase might not have featured in these cases, but a broad concept of Aboriginal disadvantage began to develop well prior to Bugmy. I did circulate a list of extracts that I'm referring to, which might assist, because it can be a bit boring hearing passages from cases read out. But the first, the process being I'm endeavouring to set out how this concept of subjective responsibility in relation to Bugmy type principle has become more nuanced in recent years. Neil and the Crown High Court per Brennan back in 1982 stated that the same sentencing principles are to be applied, of course, in every case, irrespective of the identity of a particular offender or his membership of an ethnic or other group. But in imposing sentences, courts are bound to take into account, in accordance with those principles, all material facts, including those facts which exist only by reason of the offender's membership of an ethnic or other group. That statement's been picked up in subsequent cases. I've included the New South Wales case of Fernando, which also refers to that exact same passage. It goes on to say, the relevance of the Aboriginality of an offender is not necessarily to mitigate punishment, but rather to explain or throw light on the particular offence and the circumstances of the offender. It's proper to recognise the prevalence of alcohol abuse and violence that go hand in hand in Aboriginal communities and the social difficulties that lead to it. Of course, that's true of many communities. The uniqueness of the position for Aboriginal communities was implied in these early cases rather than the heart of the matter addressed. In 2002, Appeal Justice Eames, in Fuller Cust, stated sentencing principles are the same for all Victorians. Race is not a basis for discrimination in the sentencing process. To ignore factors personal to the offender and his history in which his Aboriginality was a factor, and to ignore his perception of the impact on his life of his Aboriginality would be to sentence him as someone other than himself. So in that phrase, we're starting to get that recognition that there's something deeper that needs to be reflected in sentencing here when you're dealing with a person to whom those circumstances apply. Justice Eames recognised not just the social and economic disadvantages which might lead an Aboriginal person to commit an offence, but also acknowledged the more complex issues of history and cultural differences that should be taken into account in order to ensure that an individual is sentenced appropriately. 7 years later, the Court of Appeal in the Victorian case of Terrick revisited the comments of Justice Wood and Fernando and appealed Justice Eames in full cust and clarified and restated and, to a degree, developed the principle further. Another case that gets referred to in the courts, it doesn't involve Aboriginal offenders, but it's a case of the Crown and McKee and Brooks, where Justice Vincent back in 2003 said, "In the course of presenting their respective submissions, counsel for the appellants placed considerable reliance upon the fact that both of their clients had developed an addiction to drugs. Each did so at a relatively early age, and each almost certainly became so enmeshed in consequence of the deprivation, abuse and disadvantage to which she had been subjected to as a young person. I accept that such experiences and drug addiction itself are capable of producing serious corrosive effects that may continue to influence the conduct of the person concerned well into adulthood, and from which in some circumstances they may never completely escape." Appeal Justice Vincent went on to state that one of the ways this could be taken into account was as part of an assessment of moral culpability in circumstances where the offending is connected to drug use. So we see prior to Bugmy a steady development of a nuanced approach to assessing subjective responsibility and its importance in sentencing, where factors not of the offender's making have contributed to the offence. Then in 2013 we got Bugmy. I'm not going to go into the aspect of Bugmy that was disappointing with the arguments raised on behalf of Bugmy, drawing analogy with the Canadian experience and the legislation in Canada. Others may address those factors. I'm trying to restrict this session to consideration of moral culpability. In Bugmy, of course, well-known phrase that many of you will deal with on a regular basis. The experience of growing up in an environment surrounded by alcohol abuse and violence may leave its mark on a person throughout life. Among other things, a background of that kind may compromise the person's capacity to mature and to learn from experience. It is a feature of the person's makeup and remains relevant to the determination of the appropriate sentence, notwithstanding that the person has a long history of offending. Because the effects of profound childhood deprivation do not diminish with the passage of time and repeated offending, it is right to speak of giving full weight to an offender's deprived background in every sentencing decision. And in the years that followed, we can see that principle mature, expand and become more nuanced still. Justice Kay in Hayfron is not a passage I often see quoted, but I'm fond of it because it seems to me to be one of the earliest stages that we see this notion of shaping responses. Justice Kay said, "The offending was not committed by a person who had the advantage of a stable upbringing and whose values had been shaped by appropriate parenting. If the same offences had been committed by an individual from such a background, the moral culpability of that individual would have been significantly greater than that of the respondent. The respondent's values and his responses were necessarily shaped by the trauma and dysfunction to which he had been subjected in the course of his formative years. While those matters do not, of course, excuse the respondent's offending, they were properly taken into account by the sentencing judge in the assessment of the respondent's moral culpability." So we're starting to see the principle mature in this sense. Rather than identifying childhood deprivation as reducing moral culpability, in which case the offender is not judged as harshly as the fictional norm, the court begins looking at the forces that shaped the person appearing before it. So why not historic forces? Why not forces of historic and systemic disadvantage? Why not inherited traumas that have echoed down the line, taking many forms neglect, loss, exposure to violence and illicit substance abuse, removal, interactions with the state, interactions with police. In order to develop arguments such as these, a practitioner needs to be able to point to evidence. Evidence of what intergenerational forces have impacted the person before the court, and evidence as to how those impacts might explain or cause offending. I'm very mindful, of course, that as everyone in this room understands, that I think Justice Bell said in his session that virtually every Aboriginal person, virtually every Aboriginal family has these experiences in the family history. I'm dealing with sentencing principle as it currently stands, and as it currently stands, due to another passage in Bugme, we have to point to evidence in the court. Herman is a very useful case, of course, 2021, DPP and Herman 2021, medium mutual citations, VSCA 160. It addresses the issue of responsibility for sentencing purposes in a clearer way than many other cases have. The Court of Appeal said, in assessing an offender's moral culpability, the sentencing court is making a moral judgment on behalf of the community about the degree of blameworthiness to be attached to the offender for the offending conduct. Determining how harshly a particular offender is to be judged and punished often requires a close examination of the personal circumstances and background of the offender and an exploration of factors which may explain the offending conduct. To the extent that the offending conduct can be seen to reflect the operation of factors which are beyond the offender's control, the harshness of the moral judgment is likely to be moderated. So we're at a point post-Herman, I suggest, where a court is entitled to look at all of the factors beyond the control of an offender that have shaped the offender and the offender's circumstances and are therefore relevant to an assessment of subjective responsibility. Following points can be distilled from Herman, and Drake's another case I included in the extracts. First, the impact of disadvantage is complex, multi-layered, non-linear, and not easily diagnosed or measured. That's an important point I'll come back to. The recognition that serious childhood deprivation is likely to make an offender less morally culpable than an offender whose formative years were not marred in that way reflects the principle of equal justice. It is the mark of a humane society that the moral judgment expressed through sentencing should take account of the lifelong damage that may result from exposure to violence or abuse or parental neglect in an offender's formative years. Fourthly, under the general approach, the relevance of deprivation to sentencing does not depend on proof of a nexus. If there is an explanatory nexus, this will warrant a reduction in subjective responsibility. Sabatucci is another case which I won't read out the passage from there, but that comes after Herman, which helps distill things further. It's no coincidence that the refinement of the Bugme principle reflects development in the cognitive sciences, particularly where exposure to trauma in infancy is concerned. There is strong evidence that demonstrates the effects of trauma on brain development and how that shapes a person's responses. Things such as impulsivity, hypervigilance, poor consequential thinking, and so on. There is scientific research into the effects upon children whose parents have been incarcerated. A lot of studies in relation to that aspect. There are studies on the experiences of children whose parents were part of the stolen generations. In the United States, there's a growing body of work on the impacts and effects of insidious racism upon individuals. All of these studies are things that practitioners can draw upon if they relate to their client. There is a lot of evidence upon the effects on cognitive functioning in adulthood of due to in utero exposure to opiates and alcohol. So when these features have affected your client and a court accepts that these features have shaped your client, it should form part of an assessment of subjective responsibility? Why not the effects of racism? Why not the effects of systemic disadvantage down the generations? Why not dispossession and the impacts of colonialism? If your client has grown up in circumstances where intergenerationally there is mistrust of authorities, particularly of police and courts, and your client is charged with escaping police custody and resisting arrest, it's surely relevant to an assessment of subjective responsibility. What is clear for practitioners, as I have said, since we're dealing with the justice system, is you need to be able to point to evidence. And that, of course, stems in part from the Bugmy decision. There's other decisions, of course, such as Munda. I was talking to Andrew Bowe about that before, and you might hear more about that later. Bugmy, just to remind you, there's no warrant in sentencing an Aboriginal offender in New South Wales to apply a method of analysis different from that which applies in sentencing a non-Aboriginal offender. Nor is there a warrant to take into account the high rate of incarceration of Aboriginal people when sentencing an Aboriginal offender. Were this a consideration, the sentencing of Aboriginal offenders would cease to involve individualised justice. In any case in which it is sought to rely on an offender's background of deprivation in mitigation of sentence, it is necessary to point to material tending to establish that background. And that confirmed the position from Terrick. The relevance of Aboriginality to an offender's disadvantaged background must be established by appropriate evidence. In this jurisdiction, one way of producing the sort of evidence to the court that can provide the necessary holistic view is the use of an Aboriginal community justice report, which some of you may have had some experience in relation to. In Herman, it was stated, reports such as the Canadian Gladue reports are important aspects of the criminal justice system, particularly in the case of Aboriginal offenders. In that respect, we note that a project has recently commenced to trial Aboriginal community justice reports. The provision of such reports in appropriate cases will constitute an important step in ensuring the just sentencing of offenders. In the County Court, we've been fortunate to have experience of many of these Aboriginal community justice reports. In very brief terms, they cover the history of the Aboriginal community for which the person belongs, including colonial upheaval, and how this relates to the individual's connection to community and country, family and kinship relations, cultural identity and well-being. They address the specific circumstances affecting the personal background, including issues such as racism, intergenerational trauma, stolen generations and contemporary child removal, poverty, education and employment opportunities. They provide a holistic account of an individual's capacities and strengths, including connections to culture and community, and also address community-based options with reference to Aboriginal support programs, groups and relationships, employment, housing and opportunities that address needs. In a case from the County Court of Tirris, stated the report provides a much more detailed and in-depth level of information about your circumstances, your family and community than is usually provided to a court. The report also provides a greater opportunity for you and your loved ones to tell your story yourselves rather than having it told by others. The ACJR also provides useful information upon which the court relies as to the relevance of your Aboriginality and to your rehabilitation. In the case of Rodimer, it was stated the reports provide a holistic view of someone appearing before the court, such as yourself. In your case, the sitting elders were complimentary about the way the report was written. I was told it had an authentic Aboriginal voice. And in the case of Morgan from our court, the report gives a comprehensive, compelling history of your disadvantaged life circumstances. It raises a cultural interplay between remorse and, for an Aboriginal person, shame. I found it extremely helpful that it sets out a number of things or supports or help to you that can start now. Not every case will have the advantage of an Aboriginal community justice report. There are other ways, of course, of providing the court with some of the information which can be relied upon to make the overall assessment of subjective responsibility. A Koori court sentencing conversation is one way, because the engagement with the elders will often draw out these issues. Another way, which should always be front of mind for practitioners, is you can provide the required information in the way you would in any other case: documents, historic records, child protection records, oral evidence from witnesses, open source material as to the history of your client's family and people. I'll now provide some examples of how the historic record can be woven in to an assessment of the subjective responsibility of the person before the court in a more direct and detailed way than we see when we go back to cases like Fuller Cust, where it's a general reference. And I've included some of these in the extracts that have been circulated. In DPP and Muir, the court at paragraph 23 stated, "Some understanding of the history of the Barkindji Nation assists me in understanding you and your circumstances and the forces that have shaped your circumstances and experiences. In 1839, massacres took place, and records indicate the recording of deaths where 46 Aboriginal people were killed by Europeans along the River Division in Wentworth. Your grandparents used to talk about these massacres with you, and it is a matter that has clearly been carried down through the generations, and the impact upon them was apparent to you as a young person. The establishment of the Aborigines Protection Act and the consequences of that, living under those conditions, having lives controlled and not in a beneficial way, are also matters set out in the report. The misguided policy of assimilation and the enduring trauma of the stolen generations, which is set out in the Bringing Them Home report, was a matter that was central to the Barkindji experience as well. In Mr Muir's case, the subjection of Aboriginal families in his community to generations of state institutional interventions, resulting in Mr Muir's repeated removal from his kin throughout his childhood and during his formative years, was also a circumstance that tied the past to the present. In another case of Jones, medium neutral citation, VCC 2022-1939, Judge Todd stated, "The history of your background of deprivation begins with a review of Barkindji history to provide an understanding of the enduring and inherited trauma in Barkindji descendants today. This account starts with the description of Barkindji country, which is river country in the northwest of Victoria, where there is evidence of 60,000 years of habitation. The report traces the decimation of the relationship between the Barkindji people and their country over the last 5 generations. The report details the different attacks on the Barkindji way of life, from the introduction of disease to the imposition of discriminatory law imposed by European settlers to discriminatory economic practices. The report also details the tenacity with which Barkindji people have retained their connection to culture, which is strongly expressed through art, family and knowledge of country. It is also a history of endurance and resilience. You, Mr Jones, participated in the process of the creation of that report, which in itself was a lengthy and very personal experience. The result is a detailed account of how your personal history and the systemic racism imposed upon Barkindji people over the last 5 generations merge. Just one example is how your whole life has been framed by housing insecurity and homelessness. While you have often had places to sleep, your presence in other people's homes often causes conflict and has left you feeling unwelcome and unwanted. The report writers observe that displacement is a recurring theme in your life and a distressing parallel to your Barkindji ancestors who were subjected to direct and indirect dispersal due to colonial policies and violence. There is a rigour and solidity to this report. It gives me the evidentiary basis to accept that intergenerational trauma is relevant to both your circumstances and to the content of your offending now before me. And I take it into account in moderating my assessment of your moral culpability for your offending and in applying more generally the Bugme principles. I've also included a case of Rottama. I won't read out the entire passage. It's quite lengthy that I've included in the extracts, but I encourage you to have a look at it if you're interested. It goes into some detail and background about Aboriginal community justice reports and the utility of them. I do want to refer to some aspects in Rotorua where the inherited traumas enduring amongst the Gunditjmara descendants today due to history is touched upon. I won't go through some of the examples. At one point it stated, "You, Mr. Rotorua, are deeply connected to all of these reference points. The stories behind each of these reference points that I've touched upon fills many volumes, of course. It is beyond the scope of these sentencing remarks to do justice to the continuing trauma that has flowed through your community and family from at least as far back as the first recorded massacre in 1834 to the present day." A little bit further on, the report sets out how intergenerational harms have impacted you in your life. I accept that intergenerational trauma is relevant to your circumstances and the criminality before me. It is significant that the prosecution make the following concessions based upon the report. The prosecution accepts that intergenerational trauma impacted your childhood with specific reference to the report's commentary on children being raised by Stolen Generation members. The prosecution submission also states, and I quote, "The prosecution acknowledges the contents of the Aboriginal Community Justice Report and accepts that structural and systemic racism and colonisation influenced Mr. Rotorum's personal circumstances and outcomes in life thus far." It's an easy proposition for everyone in this room to accept. But to my mind, that's quite a significant moment and concession when the state is conceding that intergenerational trauma, the impacts of colonisation, have directly impacted the person before the court, their personal circumstances and outcomes in life thus far. The court went on, "I too accept that structural and systemic racism and the continuing impacts of colonisation have shaped you and your life circumstances thus far. The Aboriginal Community Justice Report helps demonstrate how your life circumstances sit in that continuum and trauma that I've touched upon and is connected to it. You don't need to have an Aboriginal Community Justice Report to provide a basis for the submission, but you need to deliver the information to the court in an acceptable evidentiary way. There's a case back in 2019-2020 of Zane Poole, which is a pseudonym, where there were excellent written submissions, also a psychological report by Camilla Roy Mann and psychologist David Ball, which went into the history in relation to Mr. Poole and his personal circumstances. And I've included an extract from that case as well. Just reading the final part of it. There are some in our community who may view the disadvantage you have experienced as confined to a generation or two, a matter fixed in time. This would be illusory. There is an unbroken line that can be drawn from your people's colonial experience in northern New South Wales in the 1830s to the removal of you as a child to the Red Cross Boys' Home and the institutional abuse that followed. That time continuum is littered and marked with stories of prejudice, subjugation, institutional abuse and neglect, trauma and disadvantage, and it is relevant to you and your circumstances because you are a part of it. Your experience belongs on that time continuum. It sits within the history and context of Aboriginal disadvantage in this country, and I give it its full mitigatory effect. So these cases hopefully give some examples of how intergenerational, the transgenerational, is entwined with the more immediate factors that shape an individual's responses in life. My personal view is it's not possible to unravel the multitude of factors that are relevant to an assessment of moral culpability and give them separate and distinct consideration. Perhaps this is what's meant in Drake and in Herman by the phrase multi-layered and non-linear. As lawyers, we like to chop things up and put them under headings. Offences have elements, plea submissions have heads of mitigation, and that's okay. That's what the Court of Appeal requires and what judges require. We have verdens, bugme, cognitive functioning, early introduction to substances, poor schooling, ADHD, all of these separate parts. But we are not the sum of these parts. We are complex individuals. Everyone is different, shaped by an endless amount of environmental, genetic and epigenetic factors. It's the relationship between these factors, how they operate upon each other, and the complexity of the result that has to be understood. I want to give you another quote and then I'll tell you where it comes from. Many of us think in Newtonian terms. We believe that systems can be broken down into individual components, and once these individual components are understood, the overall behaviour of the system can also be understood. A system is the sum of its parts. But while this may be true for simple systems, it's not the case for so-called complex systems. Complex systems are much more than the sum of their parts because they exhibit complex behaviour. This behaviour arises not because of individual components in the system, but because of the interactions between these components. These systems exhibit non-linear behaviour. Small causes can produce large effects. They are open systems. They interact with and respond to their environment, and they are adaptive and produce emergent behaviour that was not designed into the system. Now that passage comes from a précis for an engineering symposium about complex structures and dealing with the collapse of the Florida International University Bridge. But I've stolen it because it sums up what I've tried to express in many of my sentences, that the whole is greater than the sum of its parts. We're far more complex than a bridge, and it's the operation of factors such as early introduction to drug use, drug dependency, ice use upon a person who's got a cognitive disability, who might also be experiencing schizophrenic symptoms, who's had trauma in their childhood, who's also grappling with the consequences of intergenerational trauma. A heading such as intergenerational trauma embraces so many factors and forces. And as a judge, looking at it alone, you're faced with the issue, well, what weight do you give it? You can't attribute necessarily a separate value to it. You can't separate Verdon's, Bugme, intergenerational trauma and synthesise each separately. They are part of a whole complex system. If intergenerational trauma or systemic disadvantage needs a ticket of admission to the instinctive synthesis process, the gateway is definitely Bugme. The forces and factors beyond the person's control that have shaped their responses. It's part of the whole person. Stepping back, it should be part of the overall assessment of subjective responsibility. It's part of the story of the person who's being sentenced, the whole person. How much of the story it represents might vary based on the circumstances of the person before the court, and the assessment of the person's subjective responsibility should be made in light of all of the relevant factors. Judges, of course, need to have all the information to make the assessment. That's the lawyer's job. The judges also need to have sufficient understanding of the true history. They need to be culturally competent, and that's a whole other story. I started with a William Faulkner quote. The full quote tells us what most of us already understand instinctively and intuitively. It reads, "The past is never dead. It's not even past. All of us labour in webs spun long before we were born, webs of heredity and environment, of desire and consequence, of history and eternity." And in closing, I'd just like to say also that I think science will have the last laugh, I suspect, on the musings of jurisprudence. And future algorithms will one day assess subjective responsibility with an intricacy and an accuracy that we can't begin to imagine at present. Thank you for listening. I don't know if we're doing questions or not. I think we've got time for one question, if anyone's got one.
Looks like we have a question from the audience. Yes. Sorry, we're passing the microphones around, so To whoever... Yep. Sorry.
Thank you. In fear of having 100 eyes over looking at me, I'll ask Your Honour this question. You just mentioned culturally competent, which I think refers to a magistrate presiding over Koori court. Would that be correct?
I was thinking of any judicial officer dealing with an Aboriginal person in any court process.
Yeah, because I have somewhat of an understanding how magistrates are appointed, to use or reference some terms that have been talked about over the last couple of days under Western law. But my, I suppose, question relates around the cultural competency of understanding or being aware of LORE for these magistrates to be presiding over Koori court.
Well, that's a big topic, and the courts are working on cultural education of judicial officers across all the courts. It's nowhere near adequate. There are a number of ways of trying to get that sort of education across to judicial officers, on-country visits and engaging with elders, particularly sitting in Koori courts one way. Aboriginal community justice reports is another way of getting that information to the judicial officer. Part of why I've been giving this address is because I'm aware everyone in this room understands most of what I've been talking about, but of course there's a number of judicial officers that might be out there that, particularly practitioners here, will have to try and explain what some of these things are all about, and that's unfortunate. It's not an adequate response, but cultural education for judicial officers is very much a work in progress. But I think your suggestion's a really good one.
We'll have one more question.
Thank you,
Candice.
Judge. Just finally, there's one question from the online stream. Do you come across many submissions from the Crown, the OPP, that accept or even mention that a person is an Aboriginal or Torres Strait Islander person and that BUGME is mentioned or addressed?
Thanks, Candice. Yes, because I sit in Koori court a lot and almost on a weekly basis, the prosecutors who sit in Koori court, at least in Melbourne, but as I understand it throughout the state, put a great deal of focus into making sure that the prosecutors done cultural training, but also Koori court training. And I've done sessions down at the OPP and I know they take that very seriously. So in Koori court, yes, quite often the prosecution will concede BUGME, almost always where it applies. And one of those cases I referred to, the prosecution went further and said that they accept that intergenerational trauma and systemic racism had affected the personal circumstances and outcomes of the person before the court. So yeah, in Koori court, very good. Outside of Koori court, it would vary. And that's one of the issues, I think, that the Victorian criminal justice system is dealing with at the moment. Koori courts have been around for 20 plus years, but now the focus is perhaps more on cultural safety and education across the system, because many people come through our court, the county court, who don't go through Koori court, who would otherwise be eligible, but their offences or it's not guilty matter. So at least as many who come through Koori court don't go through Koori court.